when I received the invitation, I accepted with alacrity, thinking it was a fantastic lineup, not knowing that when it came to the conference, we would be in the middle of a general election campaign. And unfortunately, the consequence of that is, as the head of a non-ministerial civil service department, I'm subject to PERDA rules, which means I can't say anything controversial. I can't say anything provocative. I would very much have liked to have responded to some of the points that were made in the previous panel, but I think that's absolutely ruled out. So I'm going to be extremely boring, I'm afraid. Maybe even more so than normal. We've done as Bill said, we've done a major piece of work on digital comparison tools. These are things that help people compare or switch, including price comparison websites, but also including apps and things that compare more than just price. We're halfway through that, a bit over halfway through, and we'll finalize this by the end of September. But I thought I would give you a view of what we've been finding. DCTs play a big role in many markets, financial services, utilities, travel, but also in other areas such as horse transport and skip hire, so I'm told. We have found several hundred operating in the UK. Our initial update paper, we found that they offer real benefits for consumers, reducing the hassle and increasing competition. But for those benefits to be maximised, a number of conditions need to be met. Consumers need to be confident enough and have enough trust to use DCTs. They themselves need to be able to operate effectively, have the necessary inputs into their work. Competition does need to be effective, and regulation of DCTs needs to be appropriate. And so we're looking at further at 4 types of possible steps we might take to maximise the benefits they deliver. Maximising consumer confidence and building trust, improving DCT's access to necessary inputs, making competition more effective, and improving regulation. And I should observe that this work is really made up of 3 of our essential tools. It clearly involves competition issues, but it also involves our consumer protection work. We have a consumer protection role. And importantly, it also draws on our very powerful and unusual markets tools. There's a lot of work ahead, but we've done quite a lot of consumer research, survey of over 4,000 people, of users, but also non-users of DCTs. And what we found is that the large majority, some 97% of internet users are aware of DCTs, and many of them have used them at some stage. Most DCT users use more than one DCT to shop around, mainly to check the price of the same product across different sites, and that's quite an important feature. Very few people thought that the DCT they observed covered the whole of market. There is a view in some quarters that these tools should be comprehensive, covering the whole of the market. Most people are aware they don't, and they're perfectly content with the coverage they have. And most users were very satisfied, or fairly satisfied, with the DCTs they'd been using, and were more likely to be very satisfied with their experience than those shopping around in other ways, such as on direct suppliers' sites. And it's worth remembering that other shopping experiences are not always ideal, even in the physical bricks and mortar world. And most thought that DCTs had led them to better choices. Most 2/3 thought the results they had matched their needs, with only 2% saying they didn't match their needs at all. And most users were pretty confident in the way they used them, and found them easy to use, reorder or filter results, and compare them on a like-to-like basis. So overall, levels of trust and satisfaction were high. But there were certain areas where we identified some concerns. Most consumers trusted DCTs to provide accurate and reliable information, often the best products, and provide them with the best price. However, they're less likely to trust DCTs in terms of how sites store and use their own personal information. and our review of the site suggests there's room for improvement in how DCTs explain this to consumers and offer users the means to control how their data is shared. Finally, consumers have a very low levels of awareness about what to do when things go wrong, as also about how the sites are regulated. Low awareness could reflect high levels of satisfaction and low levels of complaint, but I think there is a presumption we would expect sites to be clear about their complaints policies, and the information they provided varied very considerably. So in terms of work going forward, we're going to look at a number of possibilities. First, on consumer confidence and trust, we're considering possible enforcement action if consumers are being misled, and second, ways in which regulation could be used to improve consumer confidence. Are there steps to refine regulation and enforcement to improve industry practice, for example, in respect of transparency and data use, in a way that increases consumers' confidence without unduly constraining DCT's abilities to deliver benefits? Inputs to DCTs, we're considering the circumstances, if any, in which DCTs could benefit from having greater access to data in order to provide consumers with a more comprehensive and competitive service. And that's intrinsic to our work in energy, banking. The open banking proposals we've got in the banking area and in energy are all designed to allow better data so that these DCTs can help consumers act in their better interest. In competition, we're considering whether there are enforcement cases to launch. These are particularly around FMNs, issues of negative matching, brand bidding, and non-solicitation clauses. And we're considering some concerns that have been expressed to us about hollowing out. And then on regulation, we want to see whether there are any changes to recommend to the regulatory framework, including the extent to which there is merit in greater consistency across sectors. Now, turning to MFNs, as somebody who used to work in international trade theory, I've never quite understood why FMNs have got imported into competition policy. Perhaps we should have wide parity agreements, maybe a better phrase to use for this in this context. We first came across wide parity agreements in our work on motor insurance, in our market investigation, which closed in 2015. And we found in that area that the MFNs were working to reduce competition, and we issued orders to have their removal in the motor insurance sector. And there's some evidence from that sector having done that, and it was an empirical judgment that the MFNs, the wide MFNs, were having this effect. There are theoretical reasons why you could imagine wide MFNs being beneficial for consumer welfare. We took the view on empirical grounds that it wasn't in this area. We took them off, and there is some evidence that competition has increased and that commissions have decreased as a consequence. In a number of the sectors we looked at, narrow MFNs are common, and these, again, could harm competition, either by reducing competition from the direct channel of the website of the supplier, or, in some circumstances, replicating the effects of wide MFNs. And it depends quite a bit on the competitive constraint provided from the direct channel. There's a strong link also to consumer search behaviour in this area. If consumers search across DCTs rather than across DCTs and the supplier's own channel, some constraint is likely to remain from other DCTs. But we have found mixed evidence on multi-homing, and our survey showed that 16% of recent comparative sites use only one, plus other channels of information, direct from DCTs. So we're looking at that whole area further. I think our general view is these are issues that have to be judged on empirical grounds, on the evidence, and we want to look at that evidence in more detail. I know that is not a view that is held in all quarters. Yes.
Maybe a few words to reflect on why is the theme of the digital economy such a priority for competition agencies today. If we look at the number of conferences dedicated to this subject, we really feel that this is the #1 problem in competition policy, and so there must be a reason why. And we hear a lot about network effects and free services, but network effects have been there for a long time. When you look at the telecommunication industry, you see network effect, and this is an industry that is a century old, so there's nothing new. And when you think about the fact that companies are using data related to consumers, all the same, this is something that's been there for a long time, and also the fact that some companies have a huge size and are defining anew the way the industry is working. When you think about Ford and what it did to the automobile industry, there's nothing new. Still, I think that there are some main reasons why there are some new things going on and why they present new challenges. I might summarize those reasons that make the digital economy a specific issue for us in regards to the question of scale, the question of rhythm or pace, and also the impact on practices. When I mention scale, I'm thinking about worldwide evolution, the question of the size of data, and also the question of the size of companies. I'll give you a quick example about data. The fact that today a company can adapt its pricing strategy under the time of 1 second and using millions of data of millions of consumers everywhere. This is something that had not been seen before, so this is something that needs to be looked into. Another example as regard the question of scale, worldwide scale, is the way sectors are being disrupted worldwide and in a very limited time basis. I think that one of the best examples is that of Uber and all other companies using that technology. When Uber arrived in the market, you were able to see on the major cities over the world, Paris, London, Rio de Janeiro, New York City, Delhi, you could see demonstrations by the taxi drivers protesting the arrival of this technology. And in this way, you could see that the technology was arriving everywhere at the same time, more or less, and creating the same reactions from the industry that was being challenged. And also an interesting factor is that in a very limited time basis, so more or less a year or year and a half, governments, parliaments, tribunals had to take a view on what was happening around the Uber technology. Was it compliant to transport laws? Was it an issue for competition? Was it an issue for social law? So at the same time, you had the same problems happening everywhere in the world. And I think that all those questions of scale, time, and practices have led to the idea that some companies were acquiring such a huge power that governments were not able anymore to react, and that maybe regulators were not up to the task in responding to those challenges. And this is maybe the background to the questions that we are looking at now. So, of course, competition agencies have been looking at the digital economy now for quite a long time and looking at it as a priority. I would say, if I'm looking at what the French agency has been doing at least 10 years. So what are the tools available for within the field of competition law to address these challenges? I think that if you take every area of competition politics, you see that we have the tools and we have been adapting the tools. Maybe there is room for further adaptation. For example, in regard to merger control. We have heard lots of debate in recent months about the question of the merger thresholds and whether we should adapt those thresholds to tackle the issue of Facebook, WhatsApp, and those other type of concentrations. And this is a good example because we are able to look at actual cases, and we are now, I think, at national level and also at the European level, able to look at those precise mergers that happened and that in some cases have not been able to be looked into by the competition agencies. And so the answer must be given. Do we need to adapt national law or European law to look at those mergers? And some countries have already given the answer, so that's the case of Germany and Austria. The European Commission is looking very closely at this issue and will have an answer in the next few months, and the same for France. So we are looking at a specific adaptation to our system to adapt maybe to this new challenge. So I don't think that the merger procedure per se is being perceived as something that is not relevant anymore. We can adapt it, and of course we will define the right balance between increased control of those mergers and also not giving too much legal uncertainty to the undertakings. A second very important area of competition policy is advocacy, and also the use that has been shown by David just now of those market studies and sectorial studies. And I think that this tool that has been used for all type of competition problems in the health sector or industry sector is really something that is extremely useful and well adapted to the digital economy. And we have also been innovative in the way that we have been doing those joint studies with the CMA and also with the Bundeskartellamt. And I think that is really a good example of how we can get together in a limited time and look at those complex new issues and to give a very precise analysis of what is going on in the market. And I really appreciated what we heard this morning, the fact that was Tommaso Valletti who insisted on the importance for a competition enforcer to really know what is going on the economy. I think this is really the basis of what we are doing and this is not always easy to have a current view, a very precise view of what is going on. And this enables us also to see if there are some competition problems going on. And right now we are finishing a sector inquiry on online advertising, and we'll be focusing on the new type of advertising that is really driving the market, which is the display type of advertising. And of course we are doing it in view of the fact that this new type of advertising is completely redefining the media and advertising sector. So this is something that is really important that we look at maybe even before that any competition issue arises. When we are looking at antitrust, maybe this is the area where there has been strong criticism in the public, and we've heard this today also, the fact that we don't see big antitrust cases, that competition enforcers are perceived not to be active enough or not to be delivering in terms of decision and even fining decisions. I'm not sure that this is the case. I think that we must find a right balance. We have some processes that are quite time-consuming, and we are waiting, of course, for some important cases to finish and to evolve to reach their final stage. But it's true that this is the case where maybe we have been most challenged. And I'm going now to the reflection on the way we can improve our action as enforcers. I think that maybe of all the things I've been thinking of this issue for some months and years now, I think that the issue of timing is really crucial. And this really leads us to some thinking about our procedures. Of course, we have some tools that we have been using in the past, like interim measures, but interim measures are designed to respond to an emergency in the market, and they are not final decisions. So interim measures are really crucial, but they are not the same as classic antitrust decisions. And when you look at the question of timing, today those cases really need, when you are really working very hard and very fast, it's really 2 years minimum. And in some cases it's more. We've been saying with the Commission that we are more in the 4 years or 5 years time basis. So we need to reflect Is it necessary to change the procedures? Is it necessary to act on the factors that make it impossible to close a case in less than 2 years? And this will need some hard thinking, and maybe there will be some hard decisions to take on this aspect. But I'm looking very closely at this issue. In which way can we gain some time? And on the way also the contradictory procedure is organized. And we have also to take into account the fact that those procedures are so long because of the way the courts are looking at our decision afterwards and the way our decisions are being challenged in court. So if we really need to tackle the issue of timing, we need also to take into account and maybe to incorporate in our thinking the question of the tribunals and the courts that are looking at our decisions. So this is really one of the issues that I think is key for the future. And maybe to close on the avenue of thought that can be used in the future, I think cooperation. We have a huge and very effective European cooperation as competition enforcers. I think maybe we need to strengthen our cooperation with the agencies in Russia and Korea. We've seen some important cases going out recently. In the US, maybe we need to have this more wide basis enforcement action outside of Europe too. I think that is an avenue of thought. And also the fact that we must incorporate in our competition thinking all those concerns that have been dealt with today: consumer protection, privacy, pluralism, innovation. I think that there is no, for me, it is very clear that those are parts of a competition policy. They are not the only part of a competition policy, but for me, they are part of the way the market is working, and therefore they are relevant factors that we must take into account in our decision. Thank you.
I'm also going to start with the usual disclaimer. I'm one of the federal trade commissioners at the U.S. Federal Trade Commission, but I am today giving you my own opinions and not those of the FTC, nor necessarily of my colleague, Acting Chairman Olhausen. But as Andreas and I were discussing, I can safely tell you it is 50% of the FTC's view, since there's only 2 of us right now. So take that for what it's worth. In the spirit of international cooperation, I'm going to actually just sort of embrace everything Isabelle said, because I think it was dead on. In fact, you sort of stole some of the points I was going to lead with, which is terrific. I was going to say how great it was in the first panel that the point was made about how really taking time to understand how markets work being an absolutely essential thing. And I was going to also build on some of the points that Bill has already made, which is to say, we don't necessarily need new tools in competition enforcement because the competition tools are not meant to be static. They are meant to be dynamic tools. We are meant to learn as the markets evolve and apply that learning to our understanding and use of the tools that we have. So I think the mistake competition enforcement agencies typically make, if they make one, is not really availing themselves of all of the tools in their toolbox. So for example, if we are just thinking about price effects and we're not thinking about innovation and quality effects, if we're not thinking broadly and we get too narrow a view, or we just are picking out that wrench all the time and using it, then that's the problem that we don't want to fall victim to. And it's not really what we're designed to do. As Isabelle has nicely pointed out and Bill has underscored, what we're designed to do is evolve along with the marketplace, because that's how we can do our job. So in the spirit of that, I'm going to talk a little bit about algorithms, which, by the way, Bill, are like not that new, right? So even pricing algorithms, right, have been around for a while. It's great, though, because we used to have conferences about big data, and I would say big data is nothing new, and now we have conferences about algorithms. I can say algorithms are nothing new. But, you know, of course, what's changing here is the same thing that's changing about data, which is the volume of the data, or the volume of the kind of technology we're talking about. But even more importantly, I think for purposes of competition enforcers, the velocity at which the technology is able to make decisions on huge, large scale, and collecting a lot of data to make it. So these are technologies right now that are that I think are at a moment of of change. And it's important that as a competition agency, we, I would definitely put it in the bucket of what is it, we don't know yet, right? So there are unqualified good things about algorithms, okay? Literally, none of you all would be here today without algorithms. I specifically was flown here on a plane, right, where they were using algorithms to make sure that the plane was on a route that could fly, and it was processing huge amounts of data, and the humans were basically just sitting there. Probably people have been sending emails and text messages and using handheld devices and computers and staying connected to things while you've been sitting here in the conference. You know, all of this is facilitated by algorithms in different ways. And so we want to make sure that we start, I think, any conversation about this by acknowledging the tremendous good this technology is doing in our lives. And in most cases, if you think about it, more data, faster reactions is actually just pretty unqualified and good. But I think the question that we're really needing to get a handle on in the competition space is, okay, but for pricing, are the consumer welfare effects as straightforward as we would like them to be? And I think pricing algorithms are raising three issues from a competition perspective. First, they may increase the effectiveness of overt collusion. Second, they may facilitate coordinated interaction in the absence of traditional agreement between competitors. And third, they may enable price discrimination strategies that lead to higher prices for certain groups. So first, collusion. A lot has been discussed about this. Of course, in 2015, the U.S. Department of Justice, which is another competition agency in the U.S., I used to work there. They're kind of okay, but not as good as the Federal Trade Commission. No, I'm just kidding. They're terrific. So they brought the first price-fixing case against two retailers who were aligning their pricing algorithms for the sale of posters online. I think probably everybody in the room at this point is familiar with this case because it was really important. It was the first time humans were using algorithms to collude, and it was great that they treated this as a price-fixing case, I think. So I won't belabor the point. I'll just say like that fact pattern is out there. So we sort of understand when we have humans agreeing to use the technology that it's the same kind of problem as when the humans just agree to price fix anyway. So then we get to this more complicated question. And of course, Ariel and Maurice have written a wonderful book, Virtual Competition, on the subject of, okay, what happens when we're worried about pricing algorithms facilitating coordinated interaction? So what happens, you know, when we have the mechanisms for coordination, and I think you all quite nicely refer to it as collusion scenarios in your book. And I think one possibility we have to be mindful of here is that multiple competitors might use algorithmic pricing software offered by the same company, and that might sort of push everybody towards a situation in which they are parallel pricing collectively. There's actually a paper by Bruno Salcedo that was put out recently discussing a dynamic economic model that he developed to look at algorithmic pricing by multiple firms. And what's interesting about his results is that he finds that the pricing algorithms can be an effective tool for tacit collusion when the potential to lead, with a potential to lead to near monopolistic pricing or supra-competitive pricing. But his model assumes that the firms are able to decode their competitors' algorithms. So they did a bit of an experiment, and it turns out most competitors that are using pricing algorithms are spending some portion of their resources trying to decode what their competitors' algorithms are doing. So this actually turns out to be the way things are working in the marketplace as well. So I think that's an important observation. But these concerns are largely theoretical at this point. But not fanciful. I don't know if you saw earlier this month, the Wall Street Journal published an article, so why do gas station prices constantly change? Blame the algorithm that was looking at algorithmic pricing in gas stations here in Europe. And I just want to note that one of the competitors in that article, since I'm a lawyer, I believe in the qualitative evidence of party statements as well as economic evidence. So I'll put this forward as a qualitative statement of evidence. The gas station operator said it had decided to use the software because of the effects of a years-long price war with its competitors, and it was trying to eliminate that problem for itself. And the study involving the operator found that the stations running the software actually averaged 5% higher margins. So, okay, a few caveats immediately. First, the decision by the gas station owner to use artificial intelligence software on its own to set its prices, to improve its position in the marketplace is not an antitrust violation. That is not a competition problem. Second, without more information, it's hard to know whether the reported higher margins were resulted from some kind of coordinated effects, because another possibility is that the software is enabling the gas station operator to engage in unilateral price discrimination, which is a topic I'm going to get to in just a second. So that I think the takeaway here needs to be, okay, well, this software appears to have changed pricing practices in this market, and we need to understand a little bit more about how that's working. So to get to price discrimination strategies that might lead to higher prices for certain groups, the CEO in the same article of the AI pricing firm basically explained in this article that the software was, and this is his quote, about making margin on people who don't care and giving away margin to people who do care. And of course, price discrimination isn't just about raising prices to customers who don't care. It works just as well for customers who care very much, but are nonetheless willing to pay a higher price because they lack the practical ability to go elsewhere. And at the same time, price discrimination can produce real consumer benefits. It can increase market output, which as a competition enforcer, we generally view as a good thing. And indeed, some products and services would not be offered at all without some price discrimination. So think about, for example, I'm going to simplify the numbers here, but let's say it costs a movie theater $20 to screen a movie. And my friend Hannah is willing to pay $14 to see the film, but my friend Emily is only willing to pay $8. If the theater charges the $14 for the ticket, then Emily isn't going to buy a ticket. But if it charges $8 for the ticket for both girls, then the theater won't recover enough to cover its costs. So this is a kind of tricky calculus. It turns out the way we currently solve this, by the way, is by charging $8 for popcorn. I think everybody knows that. But so pricing algorithms, are undoubtedly going to lead to price discrimination. This is not altogether a bad thing. But I do think we need to start looking very specifically at the facts and circumstances in individual markets and understanding the technology and how it's working. So I'm going to wrap up just by looking at quickly some of the pros and cons of some of this technology for antitrust enforcers and for consumers. I think algorithms' effects are ambiguous when it comes to pricing, but they're pretty positive in most other areas. And the simple answer to why that's the case, I think, is because, in a funny way, the pricing is an activity for which our human limitations may actually be generating some very positive social externalities. So one of the challenges here is when we start to eliminate the human beings from the business strategy and the decision making, whether we are going to continue to have those externalities. So what do I mean by that? Well, vigorous competition occurs in many markets, despite the fact that those markets have attributes that make them relatively vulnerable to coordinated conduct. And in many instances, this is essentially the collective failure by the human beings and the market participants to solve the prisoner's dilemma. So all firms would be better off if they paralleled one another in pricing, but each individual firm is better off undercutting its competitors to earn additional sales, right? We all know that. And our antitrust laws are actually designed to encourage this failure. So, up to and obviously including jail time for those that attempt to solve the prisoner's dilemma by actually calling up their competitors and making an agreement. The promise of algorithms and AI, though, is really their ability to transcend human limitations and produce better outcomes by processing more data faster. And the issue is that the better outcomes from the perspective of the firms won't always align with better outcomes from the perspective of consumers. So if algorithms enable firms to solve their unique prisoners' dilemmas without resorting to overt collusion, that would be great news for them, but potentially bad news for consumers and competition. What policy and enforcement choices should we make when it comes to pricing algorithms, though? It's probably easier to start with the ones that we should absolutely not make, in my view. So first of all, we shouldn't outlaw pricing algorithms. Algorithms are right up there with like the printing press when it comes to their contributions to our modern economy and all of the innovations that we're all benefiting from. They have the potential to produce real consumer benefits and make more products available to people. And we've had a lot of discussion about that today already. I think they also can identify they can help firms identify market changes more quickly, and I think that is pretty much unambiguously a good thing in many cases. So what revisions are required? I think first, as I started and as we've been discussing, it's important that antitrust enforcers understand how algorithms and AI software work in particular markets. And at the FTC, we've actually taken the step of building on our in-house ability to understand the technology by creating the Office of Technology Research and Investigations, or OTEC, and staffing it with actual computer scientists and technologists to help us understand in real time what we're seeing in the marketplace and what the technology is actually doing. I really believe that the technologists in the future are going to play an incredibly important role in competition enforcement as well. And so my future vision for the FTC would be to sort of staff up our technologists in the same way we rely on economists in doing our work. I also think it's going to be really important that we start to understand this issue about coordinated interaction and what conditions in which it may actually arise. I think it would be really helpful research in general for the agencies to look at whether algorithms are commonly resulting in coordinated effects and the kinds of conditions that exist if that is occurring in a market. And I think we need to continue to work across really all the agencies and through global cooperation and understanding some of these dynamics, because they are evolving very quickly, and we need to build our understanding right along with them. And I think the last frontier is as the technology running the algorithms gets even smarter, as it becomes truly autonomous, what is it possible that it will tend to achieve a collusive outcome without even being programmed to do so? And what is the role of the human beings at that point who are overseeing that technology? And I think that's an area that we all collectively have some work to do around. So I'm going to conclude with the quote from the Staples CTO in that same Wall Street Journal article that I've been referencing, and he sort of explained it really well. He said, this is literally his words, "If you completely let the software rule, then I could see collusion happening." And he essentially went on to say, but that's not happening because human business logic is still running the technology. And I think the real question for all of us is, like, what happens when the human business logic is no longer running the technology, and what do we do at that point? So I'll leave it there.
An essential ingredient of any economy and of any society is trust. We now live in a world of mistrust. Against this collusion between trust and mistrust, what can antitrust do? I think this is, in a hidden way, the theme of this very exciting day. I must say, I never was at a competition policy conference which brought so nicely and problematically together the competition enforcement side and the political side of things. And this is indeed particularly interesting for me, given the dual experience to which Bill kindly alluded. So perhaps I will make a few retrospective reflections, linking them to what we see today and to what we discussed so intensively today. Yes, it was called the new economy around the year 2000, the thing that we were beginning to see. There was the internet bubble. In terms of concrete antitrust cases, Bill and I and others have a vivid memory of cases like, Vodafone Management just a few years before, AOL Time Warner, Vivendi Seagram. Seagram was, of course, the parent company of Universal, the mounting new phenomenon of electronic commerce. And I remember a conference at the Bundeskartellamt in Berlin, I discovered 16 years today, which was on the new economy. And there were around Europe and around the world two rather strong convictions at the time. One was that the new economy will not need competition enforcement because it is inherently competition friendly, bringing, as it promised to do, and as it did, as a matter of fact, an increase in transparency, a huge growth in the size of markets, lowering the barriers to entry for companies, and a reduction in transport costs. Nothing like this could be dreamed of by competition authorities. This, of course, was true. At the same time, we have seen in the discussion today a number of problems that have not been self-corrected by markets, by no means. And the other view was that if intervention by public policy is needed in the new economy, then it will have to be sectoral regulation, not competition policy, because it is so new, so specific, so technologically unique. Many of us thought, I was among them, that both propositions were wrong, that indeed the new economy phenomena did need, like any other phenomena, competition overview and competition enforcement, because we were not sure of the self-correcting properties, particularly of that kind of markets. And secondly, that the instruments with which we work, both in the US and in the EU, and now gradually throughout the world, the competition instrument, as Terrell underlined so well, are greatly adaptable, amazingly adaptable, and we have seen this. So what I would recommend to younger portions of the audience, that is 100%, is to reflect on a point, on an attitude, namely, when faced by shockingly new phenomena, it is probably appropriate to be relatively unimpressed. Because it is unlikely that the new phenomenon may not need competition enforcement. And it is very likely that the instruments you have in your hands can be adapted with appropriate reflection to the new phenomena. An aspect which worried us to different degrees in the US and the EU at the turn of the century was the growing power to leverage that companies had. And the view that said it is unlikely that we need competition interventions said that a position of market power may be temporary in the new economy, in the absence of anti-competitive action, but anti-competitive action by the company with market power would render that temporary strength permanent. And we have seen that, and we have seen also the ability and willingness of companies to leverage that strength onto other markets. The other point I would like to briefly reflect upon is a big disappointment that I had today, because I had been as well as DG Competition at my time, we had been credited, particularly from the US side, but ultimately also in Europe, and very much so in the UK, which was an integral part of Europe, for having brought explicitly the consumer welfare as a standard into our system. And in fact, as a corollary to that, the more economic approach was introduced, and the predecessors of Tommaso Valletti were introduced into the position of chief competition economist. Now, I see that the consumer welfare is rapidly falling out of fashion, judging from today. So maybe I now think that I should have been more unimpressed when the pressure was there to introduce consumer welfare. But I will reveal to you two meta-economical reasons why I was taken by the idea of introducing consumer welfare. One was to fight the emerging economic nationalism in the European single market, which was coming up in those years. So the more we were able, I never really believed that the stories about the gap under the merger regulation, etc., were all that serious. But I needed anchors so as to be able to resist more strongly, more fiercely, to political pressures that would derail the competition enforcement. That, to me, was much more important than all the sophisticated discussions about the gap. And if you adopt the consumer welfare principle, however adapted, then you have an imperfect but rather objective reference. And you can use that in order to limit the intrusion of economic nationalism, which, of course, if you work for the European Union, you do not like, quite aside from its effect on competition. And also, it was, I think, almost of geopolitical importance to increase an harmonious cooperation between Washington and Brussels. And here I want once again to pay tribute to Bill, who has been the most authoritative and consistent cultural intermediary when there was need, and at some moments there was need. Maybe not necessarily with what I learn is the perfect between the two antitrust agencies in the US, but with some of the many others. And it was, I think, very helpful to have that greater convergence. I say this, and I conclude on this, because I was very interested this morning by the comments made in the first place by Sir Peter Roth and Alec Burnside and others on the basis of the Telia-Sonera ruling, which broadens the scope, public interest, individual undertakings, consumers, thereby ensuring the well-being, the bien-être of the EU. At other times, the mere use of a French expression, which is, of course, the language used by the court, but in a judgment on competition, would have given a sense of cultural extraneity and impossibility of mutual coexistence, but it's no longer like that. And here comes in populism. It was said that particularly in order to cope with populism, and populism, of course, does not like, by definition, technocracy and independence from politics. In order to cope with populism, it's important to broaden the standards and the objectives. I agree with this, but with caution. For example, Philip Blond argued the need to introduce explicit political demands. That is very transparent, honest. I think it would be even constitutionally appropriate and correct. And he developed a thinking about the huge importance of technological evolution and the possibility that concerning each individual sector there may be political objectives. But I think the international dimension there, with all due respect, was completely neglected. My concern is, and this is just a question that I put to all of you, what would be the consequence in terms of A, fragmentation of now globalized markets, and B, in terms of cooperation among antitrust authorities, if there was this input of explicitly and admittedly political objectives. If I look at the EU, that expression of a policy interest is normally left to the level of the member states. And it would be therefore to be expected that there are maybe 27 different political objectives. What happens to EU competition enforcement? And in terms of international cooperation, let's just consider the transatlantic dimension. It was said that, of course, the identification of the public interest and the political objectives comes from the legitimate process of a democratic election. Now, assume, this is just an example, it could be any other president, but President Trump heralds the principle of America first. If I were a US competition enforcer, how should I behave? Suppose there is a merger coming up between two non-US companies in a market dominated by 2 or 3 American companies. I, as an antitrust enforcer, want to apply American law, case law, etc. But I have to interpret the America First principle because the democratic process brought to that. How should I interpret it? Did the president mean American industry first relative to industries elsewhere? Or did the president mean American consumer first relative to consumers elsewhere? I have no idea. I'm sure my American colleagues do. Terrell. So in one case, the merger should be blocked. In the other case, the merger should be cleared, ceteris paribus. So I urge everybody to consider what would be the side effect of this in terms of what we all tried to build up, that is a system of international governance of this particular but not irrelevant aspect of public policy. Thank you.
I would very much like to give a perspective of the environment of which I believe that competition agencies work in for the time being. What are the difficulties? Why is this misconception here that we have so little enforcement, whereas I think we have a lot of enforcement? And I would very much like to take a little bit a look into the future, all that in 10 minutes. Mrs. Merkel, the Chancellor of Germany, has said, it was a year ago or two, she said, well, the internet is still Neuland, new land, new country. And of course, everyone in Germany laughed about Mrs. Merkel. The internet, new land. This old woman, she has not understood the internet, of course, of course. I don't think this is what she meant. And in a way, I firmly believe that the internet, or the digital economy, I would prefer, is new land for competition agencies as well. And I want to make clear why I firmly believe that. I believe we, for the time being, we work in a quite difficult environment. All we know is that this ordoliberal perfect condition of competition, where you have a market with 10 competitors and 10 competitors struggle for market share, I mean, that is definitely gone in this digital economy. We have a monopolistic market. If we are lucky, we have an oligopolistical market, but we definitely don't have this kind of struggle for market shares, which means for us as competition agencies that unilateral conduct, abuse cases become a center part of our work, which means also everyone who does these kind of cases from time to time, that we are sometimes some kind of regulators. But we are regulators who do not have a law which says if you find A, then B, and if you find A and B, then C and D. We have a law which says, well, we need competition in a market where there is no competition and where probably there will be no competition. So that is quite complex from my point of view. Then we have various developments, and unfortunately they all go into various directions. We have markets that are said to be very dynamic. At least everyone always said how dynamic the digital world is. We have consumers who are put into control. They can buy online, everywhere around Europe, through the internet, stationary, online, Amazon, whatever. On the other hand, we have an economy that is characterized by few big companies. And these companies have high market shares, and not only since yesterday or the day before yesterday, they have high market shares for years. It was clear that Mundt this morning, when you had to describe how one platform had to be replaced by another platform, huge platform, you had to go back to when, 2004? That was when MySpace was replaced by Facebook. But this is the last time that I remember that a huge platform, and I remember the journalist sitting in the office of my predecessor, Mr. Böge, saying, Mr. Böge, when are you going to intervene against MySpace? Why aren't you doing anything? That was the early 2000s. And since then, kind of these things has not happened. So sometimes I have this suspicion that is also always said by Hal Varian, competition is only a click away. Sometimes I doubt that. What is true is the competitor is a click away. But if that is a competitor that is able to coerce competition on the incumbent platform, that is another issue. And this is why there is a lot of talking in this sense, and maybe we better go back to figures, to data. Another issue that might be critical in the future, we have new developments. We have all these new boxes now in our living rooms. They're called Alexa or Echo, and we just ask that box and it is going to answer us. Well, if we're lucky, it finds a good answer. But isn't that something that will foreclose the internet? As long as you are sitting in front of your screen with various icons you can click on, you still have a choice as a consumer. But I'm pretty sure you will not have 4 or 5 of these loudspeakers and these boxes in your living room. So this might be an instrument for the future to foreclose the internet and to direct the consumer just to this kind of device. Well, that might be a strategy for foreclosure, a completely new development. We as competition agencies, we have to work with new parameters to assess market power. I mean, if we had had this conference 5 years ago, I think this issue of direct and indirect network effects, the question of tipping, the question of multi-homing, single homing, I think we would have discussed what is this and does this happen. Today we take that for granted, but that does not mean yet that we have understood everything that is around that and that we are able as competition agencies to assess appropriately what is a network effect. Does it happen here? Does it not happen? I think that is very difficult as well. Another issue is data. We all agree that data is very important Together with the French authority, we have done a study on data and how much it matters. The only problem is it can matter. It does not mean that it always matters, because you can buy data. Data can be reproduced, at least in some cases. So not easy to decide in some cases what kind of role data really plays. So if you look at it all, you have new markets, new business models, new players. We have new criteria to assess market power. We have powerful companies. We have markets with no financial transactions. In some jurisdictions, hard to assess, not very obvious. We have a law that does not include all this. And we have, at least in Europe, practically no jurisprudence. We are very happy if the European Court of Justice will take a decision now on the question if the prohibition to sell goods via third market platforms, if that is a per se breach or not. So if we have this kind of jurisprudence in the near future, there's one question that is clarified. One out of thousands that has been with the European Court of Justice. By the way, we do not have jurisprudence by the Federal Supreme Court in Germany as well. And in Europe, we have this additional problem that we have to coordinate. I mean, I do not know what conference managers would have done without the different decisions on MFN clauses in the booking case, you know. I do not know what they have done without this question about third-party platforms. Is it a per se breach or is it not? So we have even to coordinate on this. Well, in fact, they are tiny questions if you look at the full scenario, but difficult as well. So what I said, despite all this, there's a huge amount of cases, MFN cases. We had this discussion. I won't talk about MFN clauses today, but I think when I heard the discussion this morning, and I heard Monsieur Chapat that even wide MFN clauses might not do any harm to competition, I think this is through in Europe, and I think we agree that it does, just to make that clear. Another thing that we have clarified. When I hear the word MFN clause, all my alarm bells ring today, because we have had so many cases here in this area. There were the booking case, the HRS case, there was the Amazon marketplace that we have done together with the former OFT. There are other cases, the Verivox case in Germany, there are others. There are a huge bunch of cases. The Audible Apple case that we have just concluded with the European Union. And of course, there is the Facebook case that we are dealing with in the Federal Cartel Office. Well, this is a pending case. I cannot say very much on it. But Maurits, every time I sit on you with a panel, I'm fascinated that Maurits says that everything is fine in this area of privacy, in this area of, I do not know why we have these kind of conferences. Everything is so fine. But I think it is because you stretch very much the consumer who has nothing else to do but sitting in front of the screen all day long, finding out what are the terms and conditions on privacy on the platform I'm just on. And if there's an update on your smartphone, you have to redo that again, visit it all. Maybe everything will be fine in the near future when you enter such a platform and this platform says, dear customer, we will not collect any data from you except you agree to the following collection of data. And then you see the 500 data they are going to collect from you, and then you are going to see the 500 points, what they are going to do with this data. And you have to click yes on every point. Maybe then the world will get a little bit better. But as long as this is not so, I am deeply convinced that privacy is a competition issue. And if you sit in front of a screen, I'm not talking about Facebook now, it could be any platform. If you sit in front of your screen and there is this scheme showing up saying, well, we have changed our terms and conditions. Do you agree to the new terms? If yes, we are happy that you stay with us. If not, goodbye. As long as this is so, I firmly believe that privacy at least can be a competition issue. Again, I'm not talking about Facebook. This is a general question and a general problem. To make that clear and to conclude, I do not believe that competition agencies are agencies to take a look at the fact that dominating or powerful companies do everything right and that they abide to the law in any sense. But if it is about data, the gathering of data, the data they need to run their business model, I think then there is a good reason for a competition agency to look into the question if that kind of data is generated in a way that is not going against the law, since this kind of data is monetized on the other side of the platform. And I fully agree, you cannot look at only one side of the platform. So what is the future in a nutshell? I think we have the tools. I'm very happy that in Germany we have amended the Act Against Restraints of Competition now, and that we have all these kind of clarifications in the law, which says that access to data is a competition parameter, that markets on which there is no financial transaction can be a market in the sense of the competition law, that network effects are a competition parameter. It does not change our world, in fact. It just mirrors the practice of the agency that we have had over years. But we do not have to discuss that in the future until the Supreme Court or until any other court. So I think this is very helpful. We also have this new threshold when we can take a close look at mergers, which is not a turnover threshold, but a transaction value threshold. Not easy to apply from my point of view, because it's very difficult to find out, are they buying just a company or are they buying a maverick for the future? Are they buying the competitor for the future? I always say, well, if I knew that well, I would be better off if I would be an investment banker instead of being the president of the Federal Cartel Office. But on the other hand, I think we will deal with it. We won't do that alone. We will do that within the context of the European Union and with our colleagues in Austria who have that same threshold now. So I think we can deal with it. Regulation of platforms is slow. I mean, we might be slow, but regulation is much slower. The legislator is always slower. It is static. Once they change the business case, you have to change regulation. That is not very promising. And the platforms are very diverse, by the way. One size would never fit all, so I would not even have an idea how to regulate these kind of platforms. And this is why I keep on telling these platforms when we deal with them, in fact, we are your ally. Because if we don't get along as competition agencies in dealing with these companies and doing it right, not in a sense that we drive down their business model, just in the sense that we find the right balance, that we pave the way for competition in this area, then there will be regulation. And this is why I firmly believe that we are sitting kind of in the same boat. If we are successful, we are happy. And I think these companies, at least in a long-term perspective, can be very happy as well. So, Bill, a very clear answer. I think we can do. I trust that we will do, but it's still a long way. And I admit we do not know everything that we should know, but we know a lot already. Thank you very much.